A Louisiana federal judge has refused to put a temporary hold on his controversial order banning federal agencies and officials from communicating with social media companies. Biden administration attorneys had asked Judge Terry Doughty, a Trump appointee, to stay his nationwide injunction while they pursue an appeal to the Fifth Circuit. After a year-long delay, the judge had issued the order on July 4th, giving a victory to Republican attorneys general in Missouri and Louisiana, and concluding that the government likely violated the First Amendment in its efforts to persuade tech companies to take steps to limit the spread of misinformation and fake accounts, especially during the pandemic. Joining me is Jess Myers, Legal Advocacy Counsel at the Chamber of Progress. Jess, I want to start with the July 4th opinion, which is 155 pages. Can you summarize his findings for us?
Absolutely. So the judge found that the plaintiffs were able to meet their burden for the preliminary injunction when it comes to state action. All this means is that when we later consider a merits decision or a merits opinion, the plaintiffs have done enough to show that this conduct is enough to be enjoined until that merits decision is heard. The order itself put out several requirements having to do with government interaction with social media. For the most part, the Biden administration defendants are prohibited from communicating with social media companies about content unless it fits into some of the exceptions provided, which were for things such as national security and criminal activity. So that order is currently in place.
Can you tell me why the judge decided, why he thinks that the plaintiffs here will win on the merits?
Importantly, what the court was looking for in this case is significant encouragement and coercion from the government. That's the analysis that these judges look for when they are assessing improper state action. So the court was considering whether any of the government's requests to the platforms could be reasonably perceived as threats, for example, to engage in censorship. And from the evidence that was presented and thoroughly discussed throughout the opening of the opinion, the court seemed to agree that there is evidence of significant coercion to engage in censorship from the governments to the tech companies. The court also assessed the extent of the government's overall involvement in the platform's content moderation decisions. And again, it presents a question as to, what is the extent that the government is just rotely requesting or reporting that content should be taken down versus strong-arming the companies, for example.
And did the judge find that the Biden administration was strong-arming the companies?
The judge found that there was enough evidence presented to potentially meet that burden required under state action. So in order to then actually determine that significant coercion and encouragement took place on the part of the Biden administration, there would have to be a merits discussion. The court now, in granting this preliminary injunction, has found that there is enough evidence to reasonably decide to enjoin the actions between the government and social media companies as we wait for a merits decision.
So Judge Doughty wrote, the present case arguably involves the most massive attack against free speech in United States history. How does he justify that or back that up?
So, again, it's coming from the extensive evidence that was discussed throughout the opinion. The judge is looking at things like, emails that were sent from Biden administration officials to the social media companies, strongly suggesting or strongly wording the government's request to remove content. Additionally, the court cited to the attempts by Biden administration or the suggestions by the Biden administration to impose regulations such as amending or repealing Section 230, which, of course, as you know, is the immunity that these services rely on in order to do content moderation in the first place. So these types of suggestions and what could be perceived as threats is what the court was really honing in on when it was making a decision that it thinks there is enough evidence there to suggest that state action occurred.
So what about the free speech rights of the federal officials who are allegedly making these comments to the social media companies?
There's a question about the speech rights of the government, which is arguably tricky when it comes to drawing a line between when the government can communicate versus when that communication arises to the level of significant coercion or impermissible state action. So that's one consideration. But there's also another important consideration here, and that is the First Amendment rights of the companies as well. Not just the First Amendment rights of the companies to make decisions as to what kind of content they choose to carry or not carry on their services, but potentially also a right to petition the government as well. These companies have a right to communicate with their government representatives when it comes to trying to become informed to make decisions about some of this edgier, trickier content that they're making decisions on. So it goes both ways. The line is less clear for government officials, but it's pretty glaring for social media companies when it comes to their own engagement, their own voluntary engagement with government.
Was it just the Justice Department that was defending this? And can you just summarize their argument?
The Biden administration, the defendants in this case, were arguing that, their conduct, of course, does not arise to significant encouragement or coercion. To the extent that they're making that argument, they are suggesting that at all times they have requested or reported communications, reported content to the social media platforms. But importantly, the decision to remove content has always been left up to the social media platforms. So the government is essentially arguing that simply submitting requests to the social media companies about content is not enough to arise to the level of coercion that we have seen the Supreme Court and other courts before determine for state action.
So is it unusual it took this judge a year to rule on this?
I don't think so. I wouldn't be able to speak to the decision making that took place for this to take a year. I think state action, it speaks to the complications that is the state action doctrine. Doctrine itself is heavily convoluted and heavily contradictory and conflicting with the cases that we've seen in the past.
The Biden administration asked the judge to put a temporary hold on the order while it appeals to the Fifth Circuit. The administration argued that the terms of the injunction were overbroad and ambiguous, saying it would leave it up to every individual agency official to have to figure out if certain online speech was or wasn't constitutionally protected. Do you think that was a good argument after reviewing the judge's order?
Yes, absolutely. As you've just said, what's concerning in this case is that the judge's decision to restrict contact between the administration and social media platforms appears to be overly broad, arbitrary, and contradictory. The Trump-appointed judge here directed federal officials to stop notifying social media companies and outside researchers of problematic content. Of course, while that order made some exceptions, as we've discussed, for crime, national security, and attempts to suppress voter rights, a lot of these exemptions are, in fact, contradictory. So, for example, the exemption allowing the government to exercise permissible public government speech conflicts with the judge's conclusion that statements by the Surgeon General and the White House press secretary violated the First Amendment. As you know, there's all sorts of content that is on the borders when it comes to criminal content, national security, et cetera. And so the order has essentially positioned companies to either speak with the government or don't speak with the government, but these exemptions are not going to be enough for there to be a clear decision as to when it is appropriate for government and social media companies to interact.
Have courts been playing an oversized role in mediating fights over how the tech giants moderate what goes on their platforms? I mean, should this be the role of the courts?
I mean, that's the interesting question, and it kind of gets to the heart of this decision, because in giving this order, the court itself is making decisions about what types of speech are acceptable and what types of speech are not acceptable. Again, we're talking about the exemptions that the order presents. And so that begs the question then, is the court also improperly weighing into editorial discretion when it makes those decisions, when it sides with the plaintiffs in this case? And if so, then is the government, the courts, are they impermissibly using state action to enable censorship on these social media platforms? And I would venture to say yes, in this case, certainly so.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Jess